Welcome to Swayam MOOC course NGOs and Sustainable Development. Unit 5, Module 37, Mechanism to Implement Environmental Laws in India. Learning objectives. By the end of this module, you will be able to learn about the mechanism on how to implement the laws in India, understand some of the environmental laws and legislations, discern the need for implementing these laws using some case studies. Environmental law. The word environmental law refers to the body of treaties, statutes, rules, and customary laws that address how human activity affects the environment. Ministry of Environment, Forests and Climate Change, which serves as the nodal body in the central government administrative structure, is instrumental in framing some of the legislations. Some of the legislations for environmental protection includes the National Green Tribunal Act of 2010, the National Environmental Tribunal Act of 1995, the National Environment Appellate Authority Act of 1997, Hazardous Waste Management Handling and Transboundary Rules of 2008, Biomedical Waste Management and Handling Rules of 1998, and further again in 2015, Municipal Solid Waste Management and Handling Rules of 2000 and again amended in 2015, E-Waste Management and Handling Rules of 2011, Batteries Management and Handling Rules of 2001, the Wildlife Protection Act of 1972, the Forest Conservation Act of 1980. Further, the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006, the Public Liability Insurance Act of 1981, the Biological Diversity Act of 2002, Coastal Regulation Zone Notification of 2011, the Energy Conservation Act of 2001. So these are some of the acts which are related to the environment and some of the most important acts. There are several acts which have been passed in the legislation, but in this lecture we will be seeing only these. The first one, the National Green Tribunal Act of 2010. The National Green Tribunal Act of 2010 is an act of the Indian Parliament that permits the establishment of a unique tribunal or organization to effectively manage the disposition of matters involving environmental issues. The National Green Tribunal was established by the National Green Tribunal Act of 2010 to handle cases involving the protection of the environment, the preservation of forests, and other natural resources. This includes the enforcement of any environmental legal rights and the provision of relief and compensation of damages to people and property, as well as matters that are related to or incidental to these cases. The National Green Tribunal is empowered to provide by an order any relief or compensation. The relief and compensation for those who have suffered from pollution and other environmental harm brought on by the laws listed in the Schedule 1 of the Act, including accidents that happen while handling hazardous substances. What do we mean by hazardous substances? Those are substances that during preparation, due to its chemical or physicochemical qualities or handling, is likely to harm the people or other living things, plants, microbes, property, or the environment. Now, what are the principles that govern these tribunal? There are 4 principles, which is the polluter pay principle, principle of natural justice, principle of sustainable development, and the precautionary principle. Now, let us see each of these. According to the polluter pays principle, anyone causes pollution should be held financially responsible for the harm it has done to both the environment and mankind. The main goal of the principle of social justice or natural justice is to guarantee equity in the societal and individual economic endeavors. Principle of sustainable development includes conservation of the ecosystem, human resources, and development of the society. The precautionary principle is utilized within the Indian environmental governance to encourage better health and environmental decisions. It is recognized in India as a crucial instrument to support sustainable development. The Kyoto Protocol imposes mandatory greenhouse gas emission reduction requirements on industrialized nations. International instruments are similar to laws and regulations created by various nations getting together to create laws that apply to them. Such international instruments are several and they all together make up to what is referred to as the International Environmental Law. The Supreme Court heard a public interest litigation, which is the PIL, underlying the dangers of air pollution created by automobiles spewing the toxic smoke as a result of the use of diesel and petrol, which is largely responsible for the air pollution in Delhi. It took the court a number of years to order that CNG and not gasoline or diesel must be used as the fuel in all public transportation vehicles operating on Delhi highways. All of this was accomplished by a public interest litigation PIL. The Supreme Court has also taken on the work of cleaning up the Ganga River pollution through the use of PIL. In the Bichri village case, the Supreme Court implemented the polluter pay principle and required the polluting industries to make up for the environmental harm that they had caused. Through the PIL, this matter also made it to the Supreme Court. Supreme Court has also undertaken the task of forest preservation very actively through the PIL in T.N. Godavarman Tirumulkand case. Next, coming to the second one, the National Environment Tribunal Act of 1995. In order to give relief and compensation for damages to people, property, and the environment, as well as matters related to it, the National Environment Tribunal Act seeks to establish strict liability for damages resulting from any accident occurring while handling any hazardous substances. It also seeks to establish a national environment tribunal for effective and expeditious disposition of cases arising from such accidents. The beauty of this act rests in the stringent liability placed on the owners of dangerous substances in the event of an accident and the subsequent harm it may cause to the public. Next, coming to the National Environment Appellate Authority NEAA Act of 1997. The Ministry of Environment, Forest and Climate Change established the National Environment Appellate Authority to handle situations when environmental permission is necessary in certain restricted areas. The NEAA Act of 1997 was established with the purpose of hearing the appeals related to the restriction of areas in which any industry operations or processes or classes of industry operations or processes shall or shall not be carried out subject to certain safeguard measures under the Environment Protection Act of 1986. Now, how do we strike a balance between development and the environment, which is a difficult problem to solve? The Supreme Court of India first attempt to address this issue was the case of Rural Litigation and Entitlement Kendra versus the state of Uttar Pradesh. In this instance, the petitioners, a non-profit organization, feared that the lessee's mining operation has disrupted the environment. The lessees enjoyed privileges granted by the government which were subject to restrictions which was outlined in a special statute. A team of experts recommended by the Supreme Court ruled that mining limestone in some regions was risky and it was detrimental to the natural balance. Although it permitted mining operations in some locations that were deemed to be safe, the Supreme Court ordered the closure of mining operations in some areas. The court took the difficulty the lessee experienced into consideration but concluded that it is a price that has to be paid for defending and safeguarding the right of the people to live in a healthy environment with little disruption to the natural equilibrium. The following is a discussion of some of the laws governing the management of hazardous waste. Hazardous Waste Management Handling and Transboundary Rules of 2008 brought out a guide for the manufacture, storage, and import of hazardous chemicals and for the management of hazardous waste. Next, the biomedical waste, which is the BMW Management and Handling Rules of 1998, was developed to address that there is proper handling, transportation, and disposal of infectious waste, mostly from hospitals, healthcare centers. Next, coming to the municipal solid waste, which is created by the common man, the Municipal Solid Waste Management and Handling Rules of 2000 was created to give the municipalities the tools they need to dispose of the municipal solid waste trash properly. Both had a amendment. The draft Biomedical Waste Management and Handling Rules was drafted and the amended in 2015, which is again the solid waste management was again amended, which is the draft solid waste management handling and management rules of 2015. Both was developed by the Ministry of Environment, Forests and Climate Change. This was in response to the shortcoming and overlaps that was existing in some categories, and this caused inconvenience in the implementation of biomedical waste. The biomedical waste management and handling was drafted, and this draft intended to deal with the management of the biomedical waste, similar to the solid waste management, which had to manage the solid waste. And the amended draft included source segregation, transportation of waste, treatment, as well as final disposal. The goal of the draft biomedical waste rule is to enable the prescribed authorities to implement the rules more effectively, thereby reducing the generation of biomedical waste as well as to ensure proper treatment and disposal, because in some instances there were infectious materials that was disposed of as waste in the biomedical waste. Next, coming to the e-waste. With the explosion of technology, we find that computers, smartphones are being discarded very often. So, we have the rule of e-waste management and handling rules of 2011, which was first announced on May 1st, 2011, and it came into effect during 2012. And this is to reduce the use of hazardous materials in electrical and electronic equipment by defining a threshold for the use of hazardous materials and to direct the country's e-waste toward environment-friendly recycling mechanism. Every manufacturer, consumer or bulk consumer, collection facility, dismantler, recycler of e-waste engaged in the production, sale or purchase of electrical and electronic equipment has to be subjected to this rule, and they should go by the provisions highlighted in the rules. Next, coming to the battery management and handling rules, this came into effect during 2001 and it deals with proper and effective management as well as disposal of the lead acid batteries. The Act mandates that the batteries be followed by all the battery rules be followed by all the producers, assemblers, reconditioners, importers, dealers, auctioneers, bulk consumers, and consumers who are involved in the production, processing, sale, acquisition, or usage of batteries, or as well as the components of these batteries. All of them have to abide by the battery rule of 2011. Now, there are other rules which are related to the environment, which includes the Wildlife Protection Act of 1972. In order to properly safeguard the country's wild animals and to prevent poaching, smuggling, and illegal trade in wildlife as well as in its products, Wildlife Protection Act of 1972 was passed. Following an amendment to the Act in January 2003 was passed, the penalties and punishment for the violation of the Act was made even more severe in the amended Act of 2003. The ministry has suggested adding stricter regulations to the Act in order to strengthen the Act. The goal is to safeguard the biologically significant protected areas as well as to protect the endangered species of wild animals, both plant as well as animals. Next comes the Forest Conservation Act of 1980. To aid in the preservation of the natural forests, the woodlands, the Forest Conservation Act was passed in 1980. Without the prior consent of the central government, it rigorously prohibits and regulates the desertification of forests and the use of forest land for non-forest purposes. The Act outlines the requirements for diverting the forest land when it has to be used for non-forest purposes such as for farming or for raising crops. Next comes the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of the Forest Right Act of 2006. This act recognizes and establishes the framework for the right of forest dwellers, scheduled tribes, and other traditional forest dwellers over the forest region in which they dwell. The Indian Forest Act of 1927 unifies the legal provisions governing the forest, transportation of forest products, taxation of the timber, and other forest products. The Act grants other traditional forest dwellers, that is the OTFD, and the forest dwelling scheduled tribes, who is called as the FDST, who have lived in these forests for generations, recognition and ownership of the forest rights and occupation of the land. The Ministry of Tribal Affairs is responsible for overseeing this action. Additionally, the legislation outlines who is responsible and who has the responsibility for the FDST and the OTFD ecological balance, biodiversity, conservation, and sustainable use. While ensuring the FDST and the OTFD means for subsistence, food security, it enhances the forest conservation regime. It aims to make up for the colonial injustice done to the FDSTs and the OTFDs, who are crucial for the viability and the survival of the forest ecosystem. Next comes the Public Liability Insurance Act of 1981. The purpose of the Public Liability Insurance Act is to give instant relief to anyone who has been harmed by accidents, so that during their working in the industry or in the manufacturing sector, if they face accident, then this act comes into force. It states that every owner must obtain one or more insurance plan that includes contract of license insurance before they begin any operation of handling with hazardous materials. Every employee needs to be insured. The local collector is authorized to confirm that if there is any occurrence of accident, then the person who is injured receives the claim amount from the body who gives the insurance. In addition to the insurance agreement, the central government also creates the money needed for compensation through the creation of the Environment Relief Fund. The collector may use this money to pay for any compensation that may be needed. Next comes the Biological Diversity Act of 2002. The United Nations Convention on Biological Diversity, CBD 1992, which recognizes the sovereign rights of the states to use their own biological resources, inspired India also to create one such act, and the Biological Diversity Act then came into force after a decade in 2002. The Act aims to preserve the biological resources and the related knowledge while also providing for sustainable access to them. The Natural Biodiversity Authority, located in Chennai, was created with the intention of carrying out the Biodiversity Act and ensuring the goals are achieved. Next is the Coastal Regulation Zone Notification of 2011, which was published again by the Ministry of Environment, Forest and Climate Change on January 6, 2011. It was issued with the goal of ensuring livelihood security to the fishing communities and other local communities who live in the coastal areas, ensuring they are protected, the coastal stretches are protected, and it promotes development in a very sustainable manner based on scientific principles. It also takes into account the dangers of natural hazards because of living in the coastal areas and ensuring that the sea level does not rise because of global warming. All this is ensured using this act. Next comes the Energy Conservation Act of 2001. This was implemented to measure and increase the use of renewable energy to ensure that energy is used efficiently and there is minimum amount of waste to the environment. It entails the requirement for appliances and equipment's energy consumption, ensures that the appliances that are used is a highly efficient equipment. It lays out guidelines for consumer energy use. It specifies building standards for commercial structures that conserve energy. Bureau of Energy Efficiency, the BEE, is a statutory body established under this act. Now let us see some of the techniques of issuing the directions. In environment litigations, the Supreme Court authority is to issue orders under the Article 32, and the High Court's authority to do so is under the Article 226, and this has taken a significant role. There are a number of such initiatives that have served as turning points for environmental consideration. First one is evolution of doctrines in environmental jurisprudence. A notable accomplishment of the PILs is the creation of specific principles to create a stronger environmental protection regime. The Supreme Court established the concept of absolute culpability for damages brought on by hazardous and intrinsically unsafe enterprises in the Mehta versus Union of India case. The Supreme Court also used the polluter pay principle in the sludge case, which is the Indian Council for Enviro Legal Action versus the Union of India case, which included a village where residents were suffering from toxic waste which was left behind by a number of chemical industries. In Mehta versus Union of India, the precautionary principle was directly invoked to prevent air pollution from harming the Taj Mahal in Agra. Expert investigations established that the Taj Mahal was negatively impacted by pollutants coming from several industries located in and around Taj Mahal in Agra. The Supreme Court mandated that potential polluters switch to natural gas as their primary industrial fuel and cease their operations near the Taj Mahal and migrate to alternate plots beyond the designated region within a certain amount of time if they were unable to procure a gas connection for the industry. The Supreme Court also utilized the concept of sustainable development in a number of judgments to strike a balance between ecological harmony as well as developmental concerns. One case that comes to mind is the Rural Litigation and Entitlement Kendra case versus the state of Uttar Pradesh. Next, coming to protection of the social environment. When issuing a ruling in an environmental dispute, the court takes the right to a sustainable way of life and healthy environment very seriously. In the CERC versus the Union of India case, the Honorable Supreme Court ruled out that workers in the asbestos sector were entitled to medical benefits and compensation for the health risk that they faced before their retirement. Third is filling the gaps in law and lacuna in administration. Majority of the time, the judges have instructed the government officials to remember that their duty is to protect the environment. As a result, instructions were given to local organizations, particularly to municipal authorities, to remove the rubbish and debris and keep the town and city clean. Fourth is environmental awareness and education. The Supreme Court instructions also included promoting environmental awareness, literacy, as well as environmental education at both the school and the college level. The Supreme Court emphasized the importance of environmental conservation in the Mehta versus Union of India case. Additionally, the court mandated that all state governments and educational boards take action to promote environmental education. To that extent, we find that in today's curriculum, in all the school level and college level, environmental education is given as a mandatory subject that needs to be studied by all the students. The public interest litigation has enabled the Indian courts to take whatever action is necessary to further this just cause, which makes it evident from the explanation that we have seen, and it has played a very important role in environmental preservation. Now, let us look at some of the important court cases that is related to environmental protection. The first case is the Mehta's case versus the Union of India for the Ganga pollution. On the Ganga bank, tanning businesses were thought to be contaminating the waterway. They were given instructions by the Supreme Court to establish effluent plants within 6 months from the Supreme Court order. It was stated that the businesses would have to close if this wasn't done. The Uttar Pradesh Pollution Control Board, the central government, and the relevant district magistrate received instructions from the court. The court came to the conclusion that life, health, and environment was of higher value than the potential job losses and the financial losses by shutting down the industries. The Ganga River cleanup effort is being watched by the court. Next is the case where the Indian Council for Enviro Legal Action versus the Union of India, the Bichri village case. A little known village in Rajasthan, Udaipur district is called Bichri. However, a number of chemical business built factories in 1998 to make hydrochloric acid and similar chemicals, and it was exported to other countries. There is still a need for this acid even though its manufacture is forbidden in European nations. As a result, this deadly chemical was created in this small Indian town. Without securing the required NOC, no objection certificate, from the environmental control authorities, some industries started producing these compounds. There were between 2,400 to 2,500 metric tons of dangerous waste which was left behind by these factories. However, the Indian Council for Enviro Legal Action, a Delhi based NGO chaired by Mehta, filed a public interest litigation in the Supreme Court in October 1989. The NGO prescribed the peasants' inhuman living conditions and asked the court to intervene. When the Supreme Court granted the petition, the ongoing battle started and it went on between 1989 to 1994. The court announced the final order in 1996. They were required to take all necessary steps to remove the sludge and other pollutants and pay the cost for the corrective action needed to restore the land and the underground water. The central government was given the authority by the court to evaluate the cost for corrective measures and recoup it from the industries under the polluter pay principle. All chemical plants in the Bichri region had to shut down according to the court order. The court ordered the companies to pay the villagers 34.28 lakh rupees, and for environmental restoration they were requested to pay 37.38 crore rupees in November 97. However, these orders were not followed. In order to make up for the polluters' 15-year payment delay, the Supreme Court assessed the compound interest at 12% on the 37.38 crore in 2011. The payment was due from the polluters within 2 months' time. Else, the court said the recovery would have to be done in arrears. This time, the polluting companies had no choice but to abide by the court's directives. So, they had to pay this payment along with interest in 2011, but they were allowed to pay in arrears. The Bichri case is very significant because it gave the people living in that area a chance to be heard through a public interest litigation. The case is a significant decision in India's developing environmental jurisprudence since it applies Article 21, which is absolute accountability and the polluter pay principle. Legislative proposals are brought before either the House of Parliament of India in the form of a bill. A bill is a draft of a legislative proposal which, when passed by both houses of the Parliament and is assented by the President, becomes an act of Parliament. However, as the famous quote goes, you can lead the horse to the water, but you can't make it drink. We can draft laws, we can draft act, but we can't force individuals to follow it unless it comes from within. A good teacher will lead the horse to the water, but an excellent teacher will make the horse thirsty first. So we need to educate our people, our citizens, on the need for environmental protection, conserving and preserving our ecosystem. It is the need for the hour. So let us see a few questions and answers in this module. What is the rule of law and its implications in the Indian legal system? To simply understand the meaning of rule of law, it means that no man is above law and also that every person is subject to the jurisdiction of the ordinary courts of law irrespective of their position and rank. The term rule of law is originated from England and India has taken this concept. Now, how are these laws implemented in India? A bill is a statute in draft and cannot become a law unless it has received the approval of both the Houses of Parliament as well as the assent from the President of India. The process of lawmaking begins with the introduction of a bill in either of the Houses of Parliament. When a law has been suggested officially, proposed, voted on, and finally written into the law books, you can describe it as implemented. So, the steps on how a bill becomes an act in the parliament is: first, reading happens. The legislative process begins with the introduction of the bill in either house of the parliament. Then there is a publication in the official gazette, reference of the bill to a standing committee. Next is the second reading, where there are two stages. First stage, there is a general discussion. In the second stage, there is a reading by clause by a select committee. The third is the third and the last reading. The member in charge can move the bill that has to be passed. Votes are taken in the House of Parliament. So the next comes the passing of the bill. Bill is passed in one house and then it is passed in the other house. Joint session approves both the bills. Joint session of both houses approves the bill. Then it goes to the President for the President's assent. Question 3. What can the government do to ensure the laws are fully implemented? The government has the responsibility to track, monitor closely through the officials and also through websites whether the laws are implemented by the industries, by the manufacturers, as well as by the common man. So, to summarize, in this module, we have learnt about the mechanism on how to implement the laws in India. We have understood some of the environmental laws and legislations. We have discerned the need to implement such laws using case studies. Thank you.